Hi, I'm Attorney Dan Scott. I wanted to talk to you just a few minutes this morning about putting property in your family's name. I do a lot of probate law, so I deal with the administration of estates, opening them, closing them. I represent people that are heirs in an estate or people that have claims against an estate. Here lately, I've run across a situation where for some reason, people have decided to put their property in their children's names. So what happens is mother does a deed conveying the property to their son and their daughter, and normally what will happen is they will retain a life estate. That is, a life estate is the right to control the property for and during their natural life. And what happens is when you do that, it changes the nature of the ownership of the property. Well, that's certainly what you're wanting to do, I suppose. Often the people given the recommendation to put it into somebody else's name have searched on the internet and have found, boy, that's a good thing. But there's some things that you need to know about before you make that decision. The first thing is that when you transfer property to somebody else, then they have an ownership interest in the property. And while mother may continue to reside in the property, the son and the daughter have what's called a remainder interest, the right to fully occupy and control the property once mother dies. Their interest is subject to the claims of their creditors. Well, what does that mean? Well, it means if they get into a problem with taxes, that means the taxing authority can get a lien on their interest in the real estate. If they get into a marital dispute, often that interest in the real estate will become part of the marital dispute because, again, it's an asset. The son has a half interest, the daughter has a half interest. Both are subject to the right of mother, in this example, to live in the property for and during her natural life. So taxes, a marital dispute, and the one that's come into play for me recently for some of my clients is that one of the co-owners gets into a financial bind. And so they get sued. Now a judgment goes down against that person. And in this example, let's say it's against the son. And now the creditor is seeking to collect the creditor's judgment by levying on the real estate. Now, that creates a little bit of a problem because you see, sister is not interested in being a co-owner with Capital One or Republic Finance or any of the other creditors that might have to sue someone to get a judgment. And mother really doesn't want the remainder interest in the property to be owned by some non-family member. But you understand that once you convey the property away to the son and the daughter, retaining a life estate with mother, you put yourself at that risk. The other thing that just came up this week is what happens when the son, in this example, decides he needs to file a Chapter 7 bankruptcy. Well, the trustee now will step into his shoes in the ownership of that real estate. And then the trustee will most likely seek to sell the remainder interest. Just like the creditor did in the previous example, the trustee will attempt to sell that 1/2 undivided remainder interest. So that creates a problem. Now, I alert you to this simply because most folks don't think that far ahead. Because, who's going to think your brother is going to get into financial problems? We don't really know what the future holds. One of the things that we discovered by the crash in 2007, 8, 9, 10, 11, whenever that was, we know that the future is not predictable. I think we all already knew the future is not predictable, but nobody thought we would go through that, right? And so a number of people went through financial problems, and now you've got judgments, and we're having to deal with those. The other thing you need to be aware of in the event you transfer this property to your son and your daughter, like we've described in this example, it will deprive you, that is the children, it will deprive them of having what's called a step up in basis. That is, if they inherit the property, when mother dies, they get the basis, the tax basis that mother had in the property. It's called a step up in basis. And so if mother's owned the property for a long time, for example, if it's a farm or something like that, or something that's been in the family for a long time, then the value has increased since mother got it. And so the children will get a step up in basis. Now, this is not an issue if, if mother bought the house 3 years ago and now we're dealing with her death that occurs 3 years later. It's not such a big issue. But if you have a farm or something like that, or something that's been in the family, there can be a huge gap between what they paid for it, that is their basis, and what it's worth on the time of death. So we need to be really careful about that. When you convey property to someone else or an interest in property, even though you retain a life estate, that is the right to occupy the property, then you're going to give them rights to that property. And those rights may end up being in the hands of a creditor. So I just alert you to this and want you to be aware of it. I recommend you get good legal advice. That's probably the best recommendation I could make for you today, is get good legal advice before you do the deed, not after you do the deed. Sometimes it's a little trouble to reset that if you've already done the deed. I hope this was helpful for you, and if it is, and you'd like to hear more, like the page, or subscribe if you're looking at this video on YouTube. Hope your day's great. I'm Dan Scott, and I do probate law.